Hello everyone. Welcome back to our channel US Immigration News. We hope you're doing great. Well, in today's video, we will be talking about US Immigration Practice 2024 noteworthy developments for employers. As we navigate the complexities of US immigration policies in 2024, employers face a rapidly evolving landscape that demands vigilance and adaptability. This year has brought several significant developments affecting the way businesses manage their workforce regarding immigration. From changes in visa regulations to shifts in employment eligibility requirements, understanding these updates is crucial for ensuring compliance and optimizing talent acquisition strategies. In this video, we will explore the key changes and emerging trends in U.S. immigration practice for employers, providing insights into how these developments impact hiring practices and organizational operations. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. U.S. Immigration Practice 2024 Noteworthy Developments for Employers. As we delve into 2024, the landscape of U.S. immigration law continues to evolve, presenting both challenges and opportunities for employers. This year has witnessed a slew of changes and proposed actions that are shaping how businesses manage their workforce and navigate immigration regulations. In this video, we will dissect the most significant developments in immigration law that employers need to be aware of to ensure compliance and strategically position themselves in an increasingly complex environment. State actions and proposed actions. One notable state-level development came in August when New Jersey Governor Phil Murphy enacted a law imposing substantial penalties on employers who disclose or threaten to disclose a worker's immigration status to evade potential violations of state wage, benefit, or tax laws. The new legislation sets fines of up to $10,000 for such offenses. Initially, a first violation incurs a $1,000 penalty, which can escalate to $5,000 for a second infraction and up to $10,000 for subsequent offenses. The fines collected are directed to the State Department of Labor, aiming to protect workers and promote compliance with state regulations. Additionally, pay transparency continues to gain traction across the U.S., with states like Hawaii, Maryland, Massachusetts, and Minnesota implementing or enacting new laws in 2024. These laws require employers to disclose detailed pay information in job postings and recruitment materials, including pay ranges and benefits. This trend builds on similar regulations introduced in 2023, such as the amendment to the Illinois Equal Pay Act, which will take effect in 2025. For employers sponsoring foreign workers, staying updated on these transparency requirements is crucial, as they intersect with the PERM green card process and H-1B visa petition procedures. Executive branch actions and proposed actions. In August, the Department of Homeland Security launched the Keeping Families Together program, a significant initiative by the Biden-Harris administration. This video allows certain spouses and stepchildren of U.S. citizens to apply for parole without leaving the U.S., thereby avoiding family separations. If granted, the parole is valid for 3 years, providing temporary legal status and the possibility of employment authorization. Applicants may also be eligible to apply for adjustment of status to become lawful permanent residents. However, this program faced immediate legal challenges. On August 23, 2024, Texas and 15 other states filed a lawsuit against the DHS, arguing that the program was unlawful. A district court has since issued a temporary order preventing U.S. Citizenship and Immigration Services from approving any Keeping Families Together parole-in-place applications. While USCIS can still accept and review applications, no approvals can be granted during this period. The potential movement of up to 500,000 workers from undocumented to documented status could significantly impact various industries and labor markets if the program is eventually allowed to proceed. In another development, the Biden-Harris administration expressed intentions in June to provide DACA recipients and other dreamers with a pathway to work visas. Although this move aims to benefit many, the concrete advantages for DACA recipients and their employers remain uncertain. Department of State actions. The Department of State made updates in July 2024 to the Foreign Affairs Manual concerning 212(d)(3) inadmissibility waivers. These waivers are essential for DACA recipients and other non-immigrants who need to return to the U.S. after leaving. The video guidance encourages consular officers to consider positive factors, such as U.S. educational credentials or relevant work experience when adjudicating these waivers. While this update may provide some relief, the process remains fraught with uncertainty and risk, including long processing times and potential re-entry bars. Department of Labor actions and proposed actions. In February 2024, the Department of Labor extended the public comment period on revising the Schedule A list, which includes occupations exempt from the labor certification process. Expanding this list could streamline the labor certification process for employers, potentially accelerating the path to permanent residence for eligible workers. Additionally, on July 1, 2024, The deal published updated prevailing wage survey data. Employers should anticipate increased wage requirements based on this data, aligning with broader trends in compensation costs. The deal also announced the decommissioning of the legacy permanent online system on December 1, 2024, in favor of the new foreign labor application gateway system. This change is part of a broader modernization effort, though its impact on processing times remains to be seen. USCIS actions and trends. USCIS completed 2 H-1B cap lottery selection processes in 2024, with a selection rate of approximately 29%. This reflects a higher selection rate compared to the previous year. However, the approval rates for EB-2 national interest waiver petitions and STEM-related petitions have decreased, highlighting ongoing challenges in these categories. USCIS also updated its policy guidance on optional practical training and STEM OPT work authorization. The new guidance provides clarity on course requirements and transfer procedures, though it introduces complexities regarding visa status changes and study abroad programs. Judicial actions in cases under review. The Supreme Court's decision in Loper Bright Enterprises v. Gina Raimondo has overturned Chevron's deference, which may lead to increased judicial scrutiny of agency rulemaking. This shift could impact immigration regulations and enforcement actions. Additionally, ongoing litigation over the DACA program and asylum policies continues to shape the legal landscape. Looking ahead, as 2024 progresses, comprehensive immigration reform seems unlikely due to the election year. However, regulatory updates and executive actions will likely persist, influenced by the upcoming November election. Employers should prepare for potential changes and ongoing judicial challenges as they navigate the evolving immigration landscape. The dynamic nature of U.S. immigration policy in 2024 underscores the need for employers to stay informed and proactive. By understanding and adapting to these changes, businesses can better navigate the complexities of hiring and retaining a diverse, skilled workforce. As immigration regulations continue to evolve, staying abreast of the latest developments will be essential for maintaining compliance and leveraging growth opportunities. We hope this overview has provided valuable insights into the current landscape and equipped you with the knowledge to effectively manage your immigration-related challenges in the coming year. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to Gen US Immigration News. We hope you're doing great. Well, in today's video, we'll be talking about US Immigration Practice 2024 Noteworthy Developments for Employers. In 2024, US immigration law has seen significant updates impacting employers. At the state level, New Jersey introduced a law penalizing employers up to $10,000 for disclosing or threatening to disclose workers' immigration status to avoid state law violations. This video protects workers and ensures compliance with wage and tax laws. Pay transparency laws have also expanded. States like Hawaii, Maryland, Massachusetts, and Minnesota now require employers to disclose pay ranges and benefit in job postings. This trend builds on previous legislation affecting employers in the PERM green card and H-1B visa processes. On the federal front, the Biden-Harris administration Keeping Families Together program allows certain spouses and stepchildren of US citizens to apply for parole without leaving the US. This video, if fully implemented, could impact up to 500,000 workers by shifting them from undocumented to documented status. However, a lawsuit from Texas and other states has temporarily halted that approval of these parole applications. The Department of State updated its Foreign Affairs Manual in July 2024 to encourage favorable consideration of 212D3 inadmissibility waivers for DACA recipients and other non-immigrants. This change aims to facilitate their return to the US but still involve risk, including long processing times and potential re-entry bars. The Department of Labor extended the public comment period for revising the Schedule A list of occupations, which could expedite labor certification for certain skilled workers. New prevailing wage survey data published in July indicates increased wage requirements for sponsoring foreign workers. The DOL is also transitioning from the legacy PERM system to new foreign labor application gateway system. USCIS has completed 2 H-1B cap lottery selections with a higher selection rate than in previous years. The approval rate for EB-2 national interest waiver petitions and STEM-related visas have decreased, highlighting ongoing challenges. As the election approaches, immigration reform is unlikely, but regulatory updates and executive actions will continue to shape the immigration landscape.